the indulgence of our colleagues. Particularly, I apologize very profusely that I always take the floor at the beginning of the impeachment trial. The reason is medical. After 2 months, it is only now that my blood pressure has become normal. But I'm now suffering from chronic fatigue. If you remember, a couple of years ago, I took prolonged sick leave because of chronic fatigue. This period's chronic fatigue might be caused by the fact that I'm suffering from what is called in layman's terms, lazy bone marrow. That is to say, my bone marrow apparently does not manufacture enough red blood cells, and I have to be injected every week to get my blood cells to normal. That is the reason why I cannot stay long. That is why sometimes when I'm speaking, I sound like I'm out of breath. Also, not only am I hyperventilating, I have palpitations when I am in trial court. Now to go to the business of the day. Some observers of our proceedings might wonder why we have spent time determining whether the specimen signature card submitted by the prosecution with the qualification that they do not vouch for its authenticity. Some might wonder why we are spending time on whether these specimen cards are true or false. The answer lies in this basic rule of evidence that is expressed in Latin as follows: falsus in unum, falsus in omnibus. This is a very serious and basic principle in evidence. Once the court is convinced that one panel has been foisting a fake document on the court will then justified in indulging the disputable presumption that if one panel has been lying on one particular, then has been lying on all particulars and will have to disbelieve everything that that panel offers in evidence. That is the scope and meaning of falsus in unum, falsus in omnibus. Lying in one particular, lying in all particulars. That's why, as a senator judge, I would like to counsel prosecution, be extremely, extremely careful, gentlemen of the prosecution, because you might be treading on very thin ice. Falsus in unum, falsus in omnibus. There was a theory expressed in this court that actually the attachments to the request for subpoena prosecution are not fake or are not forgeries because they are simply, as the bank official testified, they are simply inconsistencies or discrepancies, which the bank official said, according to their count number, over 40 inconsistencies or discrepancies. Thus, we have to turn to our penal code to determine whether the specimen signature cards, both from the bank and from those submitted by the prosecution, constitute falsification. Under the Penal Code Article 171, as related to Article 172, falsification is, by among other methods, committed by, quote, making any alteration or intercalation. Intercalation means insertion in a genuine document which changes its meaning. And by the way, there is a difference between the term forgery and the term falsification. Under the Penal Code, the term forgery is usually applied to banknotes. For example, if you print Philippine pesos or US dollars, then you're guilty of forgery if you are passing off these counterfeit notes as genuine. But if you are falsifying a commercial paper, like a specimen credit card of a bank, that is the crime of falsification. And it is a crime to knowingly introduce in evidence in any judicial proceeding such a falsification. I have a whole list of cases that I looked up when I left the session hall yesterday, but I will just quote a 2010 case because, as you know, in law, the later the decision, the more authoritative it becomes. Ramos v. People, 2010. The elements of falsification of commercial documents are, number one, that there be an alteration or a change or intercalation or insertion on a document, that it was made on a genuine document, that the alteration or intercalation has changed the meaning of the document, and that the change made the document speak something false. That's the Supreme Court speaking on what is a falsified document. Now, maybe some of us might think that we should call for a handwriting expert, but that is not the jurisprudence. We don't need a handwriting expert because jurisprudence tells us that mostly courts disregard what a handwriting expert says, and it's up to the judge to determine for himself visually whether what he is seeing before him are, as described by the Penal Code, changes or insertions that tend to give a different meaning to the document. So the importance of this topic in our impeachment proceedings might overshadow the need to hurry and finish the impeachment trial, because if we can prove, if there is proof on record that the signature specimen cards were falsified as falsification is defined under the Penal Code, then perhaps the court might lean towards considering the maxim, falsus in unum, falsus in omnibus. It is not relevant to say, anyway, the people responsible will have to be accused in a criminal case, and so you have to find somebody who will file an accusation against them. That is completely irrelevant. The question before the impeachment court is, does this Latin maxim, false in one particular, false in all particulars, apply to the instant specimen cards? Thank you.
Thank you. Majority Floor Leader. What's the pleasure of the counsel for the defense?
Thank you, Your Honor. Your Honor, please, before we start today's proceedings, may I be allowed to make a short manifestation, Your Honor?
Proceed, you have 2 minutes.
I would like to appeal, Your Honor, to this honorable body for a re-examination, Your Honor, of Rule 17, Your Honor, of the impeachment court, Your Honor. The rule reads as follows. If a senator wishes to put a question to a witness, he or she shall do so within 2 minutes. A senator may likewise put a question to a prosecutor or counsel. He or she may also offer a motion or order in writing which shall be submitted to the presiding officer. We are pleading for an examination of this rule, Your Honor, to avoid the usual occurrence of what is known as mistrial, Your Honor. Because while it is true that the proceedings of this court as of the moment may not amount to a mistrial, it is equally discernible that it may be raised in the future in the event that the situation goes worse than this. And the reason for this, Your Honor, is counsel, whether private or defense counsel, is precluded from raising an objection or arguing with a member senator, Your Honor. This is not the same rule that we have before, because in the old rule, Your Honor, there is that opportunity for counsel representing an impeached public officer to object to any question raised by the Senate member, Your Honor. And if the objection is raised, the court is under legal obligation to examine the same and deal with its merits. In other words, it is ruled upon whether by the presiding officer whether it should be allowed or not, Your Honor. Now we say that this may amount to a mistrial, Your Honor, because there is nothing left in favor of an impeachable public officer or an impeached public officer. He cannot object, he cannot make any manifestation, and in all probability, as what we have noticed before, the question of a member of this court centers on practically everything, Your Honor. One question may be raised, followed up by another, leading to a request for the issuance of an order requiring the production of certain documents, which document had not yet been proved to be material to the issue or relevant to the subject matter under discussion. Under such a situation, Your Honor, notwithstanding the fact that the counsel or the defense counsel in this particular instance moved for a denial of the motion, still the order is granted, a subpoena is issued, and notwithstanding the fact that a motion for the dissolution or quashing of the subpoena is made, it may likewise be overruled. Under such a situation, we have no other recourse before this honorable court, Your Honor, and probably the only recourse is to go to the Supreme Court of the Republic of the Philippines. Now, that will be rather not only burdensome, but almost a nullity as a remedy, because it will take time before preparing the necessary pleadings, before the same is scheduled before the appellate court, and before any action can be made on the matter. In other words, we may come into a situation where the Tagalog, anim pa ang kabayo, anim pa ang damo kung patay na ang kabayo. If the remedy may be granted later, but the proceedings went on, and there is that violation of the constitutional rights of an accused, we submit, Your Honor, that these are reasons enough to warrant our plea for a re-examination of this particular provision, Your Honor, not to favor the defense, much avoid what is known in law as a mistrial, which may ultimately result in the nullification of all the proceedings that were held under the old rule, Your Honor. We believe that this is not only asking justice for the defense, but likewise for the prosecution, because the question of the member senator, Your Honor, may be favorable.
Court is not objectionable by either side.
Yes,
To clarify facts, to clarify, to obtain information that is vague or rather not understandable by any member of the court.
we submit that they are not objectionable, Your Honor.
Okay.
But first and foremost, may we be enlightened as to why the right to object against any examination question by a member of this court is now prohibited or prescribed under the new rule, Your Honor.
Well, that is the rule adopted by this court, and frankly, I'm not privy to the adoption of this rule. I do not know when it was adopted, but anyway,
When we were,
it was adopted, I think, during the preparation of the impeachment trial for the former ombudsman.
when we were examining towards the root of this change, Your Honor, we found out that the right to object has been granted to counsel and or his impeached client, Your Honor. We would like,
This was during the time of the trial of the former president.
Estrada, that's correct, Your Honor. And since then, there was no impeachment proceedings that had taken place sufficient enough to show any flaw, any evil, or any wrong attendant to such a ruling. We were surprised, Your Honor, why that particular portion of the old rule had been totally obliterated and taken off the present rule now.
Well,
Because
Your
it
Honor-
may not, our position is that
let the counsel for the defense.
Yes, I thought it was done.
All right. well,
our point, Your Honor, is to make the rule more in accord with the constitutional requirement of on the matter, especially the Bill of Rights, which grant to every person the right to life, liberty, and property. He cannot be deprived of any of these things without in violation of the due process clause.
Yes.
It is our humble submission, Your Honor, that with the old rule there is greater attachment, there is greater adherence to the observance of the protection of the right to due process, Your Honor.
We are conscious of that, Mr. Counsel, and I cannot rule on this at this moment. This has to be taken up by the court in a caucus, as we have practiced in order to arrive at a reasonable resolution of the issue you have raised. But I can assure you that as much as possible, we will try to accord the respondent a fair trial, observing not only substantive but procedural due process, in order to not to intrude or rather derogate anything from the application of applicable provisions of the Bill of Rights. Now, may I ask a question from a member of the court to test the credibility of a witness presented by either side? Would that be acceptable to both sides?
Acceptable to the prosecution, Your Honor.
How about the defense?
With more reason, Your Honor, if the purpose is to test the credibility of the witness on the stand who is under examination, we can interpose no valid objection, Your Honor.
Yeah. And,
We're in total conformity and in full accord with that suggestion, Your Honor.
And for instance, the presiding officer extensively questioned two witnesses for the prosecution yesterday, precisely because of the fact that the issue involved an attachment to the request for a supplemental subpoena duces tecum to produce a document desired from a bank covered by certain laws that in turn covers the document with a certain amount of confidentiality. So I do not know whether that is objectionable to the defense.
To us, Your Honor, we could interpose no valid objection to such a procedure, Your Honor. But if the questioning by way of testing the credibility of the witness will amount to, let's say, discovery again of certain documents, and then he is ordered to produce without the benefit of a subpoena, Your Honor, that is worse than a subpoena itself, because a subpoena duces tecum may be quashed, may be objected to, but if there is a motion on the part of the member of this court requiring a particular witness on the stand to produce document, automatically is under legal obligation by direction of this honorable court, Your Honor. We are not saying that it is not valid. We are not saying that it is illegal, Your Honor, but it borders on what is known as gray area, whereby the right of a party on the stand may be prejudiced, and also the party under trial, Your Honor.
Well, we'll take note of your
We are not,
manifestation.
before we end, Your Honor, it is not our purpose to have a drastic action on our plea, Your Honor. We are pleading this matter to be brought to the attention of this honorable court only for purposes of examination and judicious evaluation. With that, Your Honor, we thank heavily this honorable court, Your Honor.
May we make